the issue in the litigation is Apple has design patents and utility patents that they firmly believe Samsung has infringed, that they have copied the design and features of the iPhone and the iPad with specific Samsung products.
Well, during closing arguments, Samsung's attorney Charles Verhoeven said, quoting here, "It's not against the law in this country to be inspired by your competition. But as you well know, the late Supreme Court Justice Potter Stewart was talking about pornography. He said he couldn't describe it, but he knows it when he sees it." Is that what the attorneys are hoping for here, that you have 9 ordinary citizens who don't have an expertise in patent litigation or patent law, but maybe they know it when they see it? They know the difference between inspiration and infringement.
We believe that to be the case, that in our opinion, and it was our opinion when the trial started, that Apple has the better of the arguments. It's patent cases and intellectual property are extremely complex cases. You have 9 ordinary citizens, and the fundamental through the trial was on Apple to take a very complex issue and issues and turn it into simplicity. And I believe that they have done that based on the reporting through the trial. Samsung has counter-arguments, but again, you know, our opinion has been that Apple, you know, has a better chance with respect to the outcome of this litigation.
So in cases like this, does it usually favor the plaintiff or the defendant?
In general, it is the plaintiff. The plaintiff has issued U.S. patents. You know, the layperson looks at that and knows that it's a governing body that has granted these patents to that, you know, party, and that often is a significant element of the case. You deal with a lot of technical reasons of why not, but the presumption is a patent was issued and that it is valid.
The presiding federal judge is Lucy Koh, and she's a former intellectual property attorney. She understands that this is complicated, and many times during the trial, she had urged both sides to try to reach an agreement before it went to jury deliberations. They refused. Why, given that the verdicts in these types of cases can be very unpredictable?
In the past, and I was with IBM, and our strategy and our current recommendation to many clients is to, you know, it's a sport of kings. That's why it's so costly. It's a clash of titans of the patent war. But there's a third party that's involved called Google. They're the elephant in the room. Google provides the Android operating system to many companies' products, including Samsung. And, you know, the earlier quote about Steve Jobs, Apple, it's a fundamental right that they believe to continue in the litigation. So you've possibly even moved beyond the pure business, should we do a settlement? Because it's Apple, and I would say v. Google, and there's many other lawsuits, especially now that Google has acquired Motorola, that there's going to be significant repercussions from this verdict and continued litigation, and really, I think it's a little bit of an Apple v. Google.
You mentioned Google being the elephant in the room. What's at stake for Google?
Well, Google provides the operating systems to Samsung, HTC, and many other parties that provide cell phones and tablets. It's their business model. Now, they did not, you know, each individual company, Motorola or Samsung, have their own specific models, but the underlying operating system is provided by Google. And therefore, I expect to see a lot of litigation that'll focus on the operating system in the future.
Mr. Ehrlichman, we have about less than a minute left. Does Apple's reputation as an innovator give it an edge here?
There's no question they are an innovator. I mean, in numerous other areas, Samsung has been an innovator. They've narrowed this down to the very specific design and features. So, you know, when we look at it, the iPhone clearly led a significant dynamic shift in the cell phone industry, and I would say the same thing on the iPad. So they have been an innovator.
And just quickly, what's at stake for both companies on the outcome, Apple and Samsung?
Well, One most likely is just a financial settlement
Right.
between the two. What could really be significant is if the court decided that there was infringement and there should be an injunction against Samsung's products. That would be a significant issue to Samsung. They would have to go back and redesign some number of their products.